our firm represents a lot of people who are charged with domestic assault or sexual crimes or sexual assault. And I'm always faced with this question because, most of these people are first-time offenders. They've never been in trouble for life. And they say, well, Mike, am I not allowed to lead evidence of my good character, my good deeds at court to show the judge I'm a good person at my trial? It's a really loaded question, and I want to give examples of how this applies in Canadian law, specifically to domestic assault and sexual assault and other types of cases too. So it's a really weird holdover for the Middle Ages. You're still allowed in a Canadian courtroom you can't, first of all, come to court and talk about specific deeds, that I'm a good person. You can't say that as an accuser. I suppose you could, but it's just garbage. You shouldn't, it doesn't help at all. What you are allowed to do, which is really a waste of time in domestic assault and sexual assault, and I've seen some lawyers do it, it's a complete waste of time because it's not given any weight, basically, in this day and age. But you're allowed to have someone from the community come who knows of you in the community, who knows of your genuine reputation. And they're not allowed to act about good deeds, but what they could say is that, look, I know of Mike Kruse in the community, and I know 40 people that know him, and he generally enjoys a good reputation for honesty and peaceableness, nonviolence. And you could lead that evidence in a domestic assault trial, and the judge will look at you and go, why are you leading this evidence? Because you know I'm not going to give it any weight. Because what the heck does that have to do with a sexual crime? Because we know what happens behind closed doors. It's really, in this day and age, given very little, if any, weight. I'll call it zero weight. It's a bit of a holdover. We still have the rule. I've seen lawyers do it. I don't know why they do it, because I can tell you it's a waste of time. Now, if you're charged with a crime of dishonesty like theft, you could consider doing it. It might be given some minor weight from the judge. But again, I, as a judge, or anyone as a judge, says, well, what the heck does 50 people in the community know about what this person truly is like? Just because they present well in the community, they could have committing adultery, stealing, fraud, Ponzi scheme, whatever. I mean, remember that guy who was defrauding people in the States of billions of dollars on the Ponzi scheme. So it's a holdover from the Middle Ages. It's still available. If I ever did it, a judge is going to be looking at it. Why are you wasting the court time, Mike, in a sexual assault trial? In the odd theft trial, I've done it just to say we did it, to appease the client. Judge gave it no weight, or basically didn't even comment on his decision when we actually won 2 of those cases. So now another thing is, you have to be very careful to a client. The client, I never want a client, you're allowed when you examine the client to introduce their background. So what I say, well, the way we'll introduce your character in a certain way is you're employed, such and such, your education, a little bit of your background. We're allowed to delve into a little bit of that, not in tremendous depth, maybe for a few minutes. The judge is going to cut me off, but that's good. It builds you up as a person. But I always say to the judge, look, to the client, never state in court, look, I'm a good person. I'm not the type of person to do this crime. That opens your character. What does that allow it to do? The rule is this: the Crown is not allowed to introduce evidence of bad character of an accused unless the accused opens the door. So once the accused says, I'm a good person, I would never do this, I've never done this in my life, I'm honest, I wouldn't rape anyone, I wouldn't steal. Now if the Crown has some dirt on you, they can cross-examine you on it. And I don't know what dirt the Crown has on a client, so I say to the client, never go down that road. So bottom line, general reputation evidence is a waste of time in most trials, if not all these days. Maybe you lead it in a crime of dishonesty. When you take the stand, never say you're a great person. Just lead I'm wonderful, most honest person in the world. Oh my God, we don't know what the heck the Crown has up their back sleeve about you. I don't know. And the Crown's supposed to disclose that ahead of time, but they don't always do, frankly. They're bad character evidence. I asked for it, but there might be something that arises at the last minute. I might not know about a crime of dishonesty that you were charged with or something. So there's a little bit of a primer on how you can introduce good character evidence just in a limited way about background, and the rest is basically a waste of time. Now, I want to mention to you that we have offices throughout the province. We're in Toronto, we're in Windsor, London, and Kitchener, physical locations, and lawyers here to serve you. And we also serve all the cities in between. But if you want, for example, a Toronto sexual assault lawyer, Toronto domestic assault lawyer, Toronto DUI lawyer, you can give us a shout, or any one of our offices, and we'll help you out and get you the advice you need. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.